Part 5 of Chapter 5, dealing with civil rights, brings us up to a more current legal and policy perspective as to what's going on with the issue of discrimination and segregation. If you remember several parts back, I made the reference that the actions of the 14th Amendment would eventually be used to address the rights of white individuals as well. The slide is the case in point that has been used or referred to at times as reverse discrimination. As you can see from the slide, Alan Bakke was a white man applied to the University of California, Davis Medical School and was rejected. The school had reserved 16 of 100 seats that year for minority applicants. Bakke sued on the basis that his grades and test scores were better than some admitted. The case fractured the court, and there was actually 6 different opinions issued. However, the majority ruled that UC Davis went too far in their effort to address past issues. The net impact was that most affirmative action programs would continue without change, but they were then subject to possible review, as we will see. I left this clicker question in the PowerPoints again to give you cause to think about what is the answer in terms of the Bakke case. While the Supreme Court said yes, there are, of course, a number of qualifications, as I've indicated, that would follow. The court ruled that because it was a quota and that it had separate admissions policy for minority students, that it was constitutional. However, the court did say that taking race into account for admissions was constitutional. So while you could not use a quota, you could take it into account if there were, of course, compelling public issues such as affirmative action. And of course, as you notice, to achieve a diverse population. 2 other cases come before the court, both in 2003, as you can see, that continue to confirm the decisions that were made with Bakke, that we have Grants versus Bollinger and Gutter versus Bollinger. Both these cases involved the University of Michigan and seem to uphold, as you can notice, both sides of the Bakke decision. That one, race cannot be the main criteria for admission, but it may be taken into account, which continues to leave the situation that quotas are, in all likelihood, not acceptable, but that race can provide a priority in terms of admission if, as it was stated in Bakke, that it served, looking for my notes, that it served a compelling public purpose such as achieving diverse student population. However, the issue of affirmative action and preferential treatment, which is basically what the term that has been applied to Bakke and like cases, seems to have different meanings in different areas. Proposition 209 came on the California ballot in 1976, which sought to ban preferential treatment for minorities. It passed with a 54% of the vote. In 1997, Houston voted, however, 55% to support affirmative action. So as we can see, to some degree, affirmative action, what we call affirmative actions, matters, and it may differ based upon location. Again, here is a clicker question that affirmative action is unconstitutional in any form, constitutional as long as race is not too big of a factor, C, required for equal protection, D, required for due process. And as we see, B is the answer that has been established again by the Bakke and Bakke-like cases. So we can see that both civil liberties and civil rights have expanded over the past century, both through court action, legal action, and people action. The expansion of civil rights has allowed more to take part in the collective decision-making process because they are no longer prohibited from taking part in the process, but it has also imposed restrictions on sorts of decisions that can be reached. Institutions have alleviated collective action, but they still are limited by civil liberties and civil rights. The problem is that we tend to look at these institutions as black and white, with discretion that leads to shades of gray, which of course then leads to a variety of questions. We continue to struggle, however, as a country, of what to do with undocumented immigrants and equal protection. The 14th Amendment states that no state shall deny any person within its jurisdiction the equal protection of the law. The question goes, how far do states have to go? The state of Texas has consistently claimed that the expense of undocumented immigrants is putting it's causing great problems for their budget. While it's probably not the final struggle in civil rights, it is definitely a controversial one. We can see in the current presidential race of the issues of citizenship versus laws versus, and as I would say, ... there doesn't seem to be any resolution. This concludes part 5 of chapter 4.